Welcome to this training, Alternatives to Conservatorship, Alternativas de Tutela. Thank you everyone for being here tonight. I know you're taking time to be present in this training, so we are very glad that you are spending some time with us tonight. We have the Disability Rights of California presenters here with us to give us this excellent presentation and training. So we are trying to record this. Please just remember confidentiality purposes. We encourage you guys to please just use your names and maybe not your last name. Mute yourself just to minimize background noise. If you want to turn off your video, that's okay, and it's preferred. And also, the presenter will let us know when it's time to do QA questions, and we'll stop the recording actually, so that we can remain, a lot of things confidentiality. I'm going to introduce myself now. My name is Patricia Idrugo. I'm the Family Resource Center Supervisor of San Mateo County, and I have here my team, the Family Resource Center staff. Sonia Valenzuela, it's the Help Me Grow and Family Resource Center Manager. We have Denise Espino Tinoco. She's our new administrative assistant, and she's here also to learn. We have Iris Wen, and you guys can wave. I cannot see all of you. You guys can wave and say hi. Iris Wen is our new training coordinator. She will be doing a lot of the trainings moving forward. And then we also have Gabriela Diaz Santos, and she's actually one of our FRC coordinators. So she, supports a lot our team. And without further ado, I want to introduce the Disability Rights California team, because they're going to be leading the presentation, and Mary and Maria will be you presenters today.
Thank you, and good evening, everyone. My name is Lonnie Pfeiffer. Thank you so much, Sonia and Patricia and the team. Welcome to our training on alternative to conservatorship. Our presenter this evening, our senior attorney, Maria Urarty, and also who will be assisting is our senior advocate, Mary Rios. I'm going to go ahead and turn it over for some logistic information. So Mary.
Thank you, Lonnie. Good evening, everyone. As Lonnie said, my name is Mary Rios. I'm one of the senior advocates at Disability Rights California. Today, Maria is going to present on alternatives to conservatorship. All the materials will be shared with Patricia and her team to share with the participants, along with any links that we share. If you have any questions, like Patricia said, you can please raise your virtual hand. The attorney will pause from time to time, and we will go ahead and answer some of those questions. Also, if you would like an appointment with the attorney, I am actually entering my information in the chat. Please feel free to reach out to me. I will do an intake, do a conflicts check, and then schedule an appointment with the attorney. So with that, I will go ahead and turn it over to Maria.
Hi, thank you, Mary. Thank you, everyone. Good evening. I hope not to make a very long training of this, so that you can get back to your life activities. But it's an important topic, alternatives to conservatorship, because I think that when, especially parents who have young adult children who are about to turn 18, they wonder about how they are going to continue to be able to make decisions. And sometimes what happens, or oftentimes what happens, is that parents start talking to other people and they say, oh, you have to get a full conservatorship, and hardly anyone talks to you about what the alternatives to conservatorship should be. Slide number 2. So before the age of 18, you're responsible for your child, really. If you're a parent, or if you're a legal guardian, or if you've adopted a child, you're responsible for the person, which they call, and it's a category which includes their health, what they wear, their housing, their financing, their education and other needs. And then of the estate is the other type of right that can be taken away in a full conservatorship, which is anything related to finances. So, I mean, it is important to know that at the age of 18, unless you have the legal right, a legal document that allows you to handle a person's, matters with regard to their person or with regard to their estate, you can't. So you could end up going into an IEP meeting, your child just turned 18, and the district can say you can't be here. And they're right, unless you have something that allows you to be there. And we're going to talk about that. So now conservatorship is not only for people who turn 18, it could happen at any age. Old people are conserved. I don't know if you guys saw the movie, and I can't remember what it's called. It came out maybe 2-3 years ago about this company that acts as a conservatee, the people who handle the matters for the persons who are being conserved. And it was just a story about how they conserved a woman who had a lot of money. Excuse me, I've had a lot of cough today, and how easy it was to do that. Excuse me, and how difficult it was to undo that. So, so just know that that's what's going to happen. Now, you see in the slide, there's a Family Code section 6550. It's called the Caregiver's Authorization Affidavit, and you'll find this affidavit, this form, in that link. What it does is allows some relatives, as defined in the Family Code, the ability to make decisions with regard to schooling for the minor and medical services at school. If you're interested in that, you can look at that. It doesn't take away the parents' rights. It just allows a relative to make those particular kinds of decisions. Next slide. Okay, so let's say I turn 18, and now I can decide what I want to with me, right? What I eat, where I live, whether I want to go to school, whether I want to get married, whatever it is. And I also can decide my finances, how I want to spend my money, if I have any money. And so, next slide. So the thing, I want to discuss, this is not a training on conservatorship. This is a training on alternatives to conservatorship. But I think it's a good idea to talk a little bit about conservatorships. Conservatorships, it's a legal process where you file a petition for conservatorship with the Superior Court in your county. You may have several Superior Court branches in your county, but you file the petition, and then there's an investigator that's assigned, and at some point in time, there's going to be a hearing on whether the person should be conserved, fully conserved, where they take away rights of the person and or maybe finances. And so the judge who makes the decision is going to have a lot of evidence before him or her about whether this person should be conserved. And so I am later going to talk about a bill that's making its way, hopefully to become law, Assembly Bill 1663, that's going to make a lot of good changes to the process, and we'll talk about that later. And full conservatorship or general conservatorship is, like I said before, for anyone 18 or over. A person can be conserved at any age should the court find that they should be conserved. So if I'm 35 and someone files a petition for conservatorship and if the judge is satisfied that I can't handle my affairs, then I can be conserved. And it could last forever for me if I'm conserved, maybe until I die, or because it's really hard to undo. And the bill that I'm going to talk about will make it easy to undo, easier, I guess, to undo than it has been, up until now. Next slide. So what is the goal? The goal is to keep the person as independent as possible. Not everyone needs a full conservatorship. And so next slide, we're going to talk about alternatives to the general conservatorship. I'm going to talk about a limited conservatorship, circle of support, or it's also called supported decision making. I'm going to talk about a durable power of attorney, advanced healthcare directives, how you can make educational decisions for someone, medical decisions, how you could get information from agencies about the person. We'll talk about all of that, and how to make financial decisions. Next slide. So a limited conservatorship is also a judicial process. You have to file a petition for limited conservatorship in the Superior Court. And the judge can only take away the rights that you see in slide 7, where you live, to view confidential records, to marry, to sign contracts, to consent to medical treatment, to control social and sexual contacts, and education-related decisions. So if my mom files with the court a petition for limited conservatorship, and she checks off that she wants to take all of these rights away from me, that may happen or it may not happen. The court may decide that, wait a minute, Maria, the only thing based on the evidence, I see before me, I think, I'm convinced that Maria really can't make decisions about who to marry or sign contracts, but I feel confident based on the evidence that all these other things Maria can do competently. So no, I'm not going to, contrary to her mother's wishes, I'm not going to take away all these rights. I'm only going to take away the right to marry and to sign contracts. Next slide. So a limited conservatorship cannot control the salary that I may earn. It can't, the limited conservator cannot approve harmful medical treatments, force me to carry out drug treatments, sterilize me, put me in an institution, make me undergo electric shock treatment or psychotherapy. Can't do that with a limited conservatorship. The power that the conservator, this is the person that has the right over me. So in my example, my mom would be my conservator for purposes of marriage and contract, right? Those are the only rights that my mom would have over me and nothing else. And when the judge approves those two things, the judge will issue what is called the letters of conservatorship, and it spells it out right there. So once next slide, once the petition is filed for limited conservatorship, and by the way, limited conservatorships are only for people with developmental disabilities. So if I have a psychiatric disability, my mom cannot file a petition for a limited conservatorship, cannot do, only for people with developmental disabilities. So, but anyway, once the petition is filed, an investigator will be appointed, more likely than not, and that investigator will explain to me what's going on. I'm the person that my mom wants to conserve, will interview me, tell me about the process, will determine whether I'm in a position to attend the hearing where the judge is going to decide which of those 7 rights, if any, if all, will be taken away from me. And will ask me whether I oppose the conservatorship and why, and whether I oppose the person who wants to be my conservator. In this case, it would be my mom, right? Maybe I don't want my mom to be my conservator. Maybe I want someone else. Next slide. The regional center is also, we've worked with different regional centers, and they say, in fact, that they do submit a report to the court, and that report will include, for example, the nature and degree of my disability, the type of assistance I need, my physical, mental, and social well-being, and recommendations on the rights that should be taken away. Next slide. The other thing that I can do is we have a sister organization called the Office of Client Rights Advocates. There's an attorney and an assistant for every regional center. They are not employees of the regional center. They are us. We're sister organizations. Their focus is to help clients of the regional center. We help people with any type of disability, including developmental disabilities. I can go to my client's rights advocate and say, hey, this is what's happening. Can you tell me? The client's rights advocate could talk to me about alternatives to conservatorship. Maybe if I want to talk to, if I have an attorney, or if an attorney has been appointed, can talk to my attorney, to the investigator. So, you know, I could get them involved in this process. Next slide. Okay, so we're going to stop right here for a moment on slide number 11. We're going to go ahead and take some questions. So we're going to go ahead and stop the recording. As being an alternative to a general conservatorship or a full conservatorship, right? So the limited conservatorship is a tool in our tool chest. We're going to talk about, we're now on slide 12, and circle of support. It's also known as supported decision making. And I mentioned supported decision making because the bill that is making its way and hopefully becoming law will make supported decision making part of the law. And we'll talk about what that means and what needs to happen before a person can be conserved, should this law pass the way it's been written. But circle of support, you as parents and family members may be saying to yourself, yeah, I know what that is. I've been the circle of support for my child since forever. And I would say, well, it's a little different in that you're the one that is doing the things. You're the one that's deciding for your family member. With a circle of support, let's say I'm the person with a disability, I'm the one who decides who I want to go to for advice, for helping me advocate for things, for maybe going to the doctor with me, for whatever life, you know, comes my way, and I have questions about maybe goals that I want to set and how do I go about doing those things. I choose who that circle of support will be. And it could not, and it's possible, and may not include the parent, you know, the parent that's been responsible, you know, for me forever. So it could be friends, it could be family. I might invite a professional to be part of my circle of support. It could be it's very informal. You don't have anything, you don't need anything in writing, or it could be more formal. Maybe I want to have, you know, a little circle of support contract where I name the people and what it is I want them to help me with, and maybe I want to meet once a month with them, or it could be less formal than that. This is something that could happen even with a limited conservatorship. Why can't the person with a disability have a circle of support to go to, right? So that's another tool. We're now going to talk about another tool that you can use. We're going to go to the next slide. And we're going to talk about durable power of attorneys. This is very different than a limited conservatorship or a conservatorship, because you do not have to go to court to have a power of attorney. It's a document. It's a legal document where, let's say I'm the consumer, I'm the person with a disability. I give someone else the right to make decisions about maybe my finances, my personal matters, medical, for example, my educational matters. I can give different people my different rights. I can appoint more than one person to have power of attorney over whatever subject. But this is the key. The key is that I'm going to be signing that document, appointing, let's say that I appoint my mom to have power of attorney over my finances. Well, I have to have capacity. And so we're going to go ahead and stop sharing and go to a document that talks about what capacity means. And so let me know when it's on, so I can, and we only have to go to the first paragraph.
It's on, Maria.
Okay, so for me to have capacity, I have to understand the risks, the benefits, and the effect of signing the document. So what does that mean? I don't need to understand the fancy language in the power of attorney. I just need to understand that by appointing my mom as the person who's going to have general power of attorney over my finances, she's going to take over my finances. I won't. I also need to understand that I can always take that right away from my mom. I can decide that I no longer want her to have power of attorney over me. I have that right to do that. I could assign someone else to have that power of attorney for finances, or I can decide, hey, forget it. I don't need anyone, to handle my finances. I'm going to do it myself. So you see where it's very different. There has to be capacity to understand the benefits, the risk, and the effect of signing. If you go to an attorney to prepare a power of attorney, the attorney is actually going to make that decision about capacity, because if the attorney feels that the person who's going to sign the document doesn't have the capacity, then the attorney should say, no, we can't do a power of attorney here, because the power of attorney, a capacity can be questioned later on. And its capacity, what matters is what the capacity was of the person at the time that they signed the document. So if I sign a power of attorney and I have capacity today and I give it powers to someone else, 10 years down the line, someone decides that, challenges the power of attorney and says that, Maria, maybe 10 years down the line, I developed dementia. But 10 years ago, I had capacity, and that's really what matters. Capacity at the time that you signed the document. So you don't have to go to court for this, but, and just know that at some point, someone could challenge capacity of the person who signed the document. And in California, depending on what it is, these power of attorneys have to be signed by 2 independent witnesses. Sometimes they need to be notarized. I hear people in these trainings saying, oh, I looked up a form on the internet and I used it. And I always caution people against using forms that they find on the internet, because every state has its own requirements for what makes a valid power of attorney. And you don't know if that power of attorney that you looked up on the internet and printed out is really legally valid in California. Like I said, there are attorneys who do this kind of work. There are estate planning, ESTATE, or elder law attorneys. They do this kind of work all the time. It shouldn't be too expensive to do this. And I would have peace of mind doing it that way, knowing that, there's someone who knows what they're doing and knows what kind of language needs to be there preparing this document. We were in a training once, Mary, I don't know if Lonnie you were on, where a mother shared that she had gone to an attorney to prepare a power of attorney, and she offered the group a copy of the power of attorney. I'm sure she will redact it to take away, important personal information. But so that could be good, because depending on the power of attorney, what it was for, but, it was written by an attorney in California, and you would think that that would be a legal document, right? So that happened at one of our trainings. Then the next tool that we have is called the Advanced Healthcare Directive. This could be for anyone. And, I have one. And what it is a form that gives another person the right to make medical decisions when I no longer have the capacity to do so. Let's say I'm in an accident, I'm in a coma. My advanced healthcare directive gives my husband the right to make those decisions. And I've already indicated in my healthcare directive what I want to happen. You know, whether I want them to pull the plug or not pull the plug, or, you know, put me on, you know, some kind of a mechanical machine to keep me alive. And so I provided an example of a simple advanced healthcare directive, but we, for example, I did an advanced healthcare directive through an attorney, and I think if I remember correctly, it was like 18 pages of questions that I have to answer that I never thought I needed to think about, right? You think, oh, it's simple, so someone can make a decision whether to pull the plug or not. It's more than that. It could be a lot more than that, a lot more decisions that this person can make. And so this is another thing that again, you know, I have to have the capacity to understand what I'm doing, right? Next slide. So let's talk about educational decisions. So very easy in the state of California, because the California Education Code, section 56041.5, and you see the link to that form in our Special Education Rights and Responsibilities Manual. And it's a form that the student would sign. In assigning, for example, I could assign my mom to continue with making my educational decisions, and the districts have to accept that form. The other way to do it, you know, I don't see why, because you could just use the form through that California Education Code. Of course, you could have a power of attorney for this. You can have a limited conservatorship for this. But if that's the only thing you're concerned about, why not just use the form that you can, that's pursuant to the California Education Code. Next slide. The right to make medical decisions. Of course, you can do that through a limited conservatorship. You can do that through a durable power of attorney. The other way to do it is I'm the person, and I want my mom to continue being able to get my medical information from my doctor or doctors, being in the room with me, participating in my medical decisions. I just get a HIPAA form from the providers and fill it out and sign it and hand it over to the doctor's office, hospital, whatever it is. And that's enough for my mom to be able to continue to participate. So I don't need a durable power of attorney. I don't need a limited conservatorship. Again, I need to understand what I'm signing, right? I've got to have the capacity. If I don't have the capacity to understand what I'm signing, the benefits, the risks, and the effect of the document, the effect of signing the document, it can be challenged. One of the things that we do is that we have the client and or the parent on the phone, and when we want medical information, we call a doctor's office, for example. I tell them that I have their patient on the line, the mother, and sometimes I can get information like that. They'll confirm that the people I set up on the phone are on the phone, and then they'll give me information. But more times than not, they'll say, no, we can't, we're not going to do it this way. If you want information, we need a HIPAA form. And then at that point, I just say, okay, well, send it to me or give it to me. Let me know where it is. Maybe it's online. I can download it and get that taken care of. The next slide. If I want general information, let's say that I want, I was involved in an auto accident, there's a police report, my mom wants to get it. Well, they have releases for that too. So we would call the police department, get the release that they require, fill it out. Remember, if I'm the person that's signing that form, I need to understand, right? And so other times we do the same thing that we do with medical information. We're on the line with, for example, an agency, and I tell them I've got the person on, like I do this a lot with Social Security. I'll call Social Security with the Social Security recipient on the phone, and we talk to representatives about the case. We can do that. It's easy to do that with them. Because what they do at Social Security is they ask the person like information that only they would know, right? I would know, like your mother's maiden name. So they want to verify that the person that I say is on the line is really the person. And once they've confirmed that, then they talk to me with the person on the phone. So that's another thing. To manage, next slide, to manage finances, limited conservatorship, you can do a power of attorney. If the only thing the person has is Social Security benefits, you could just be the representative payee. You don't need anything else because there's nothing else to handle, right? It's only the money that's coming from Social Security. And as a representative payee, you have to, Social Security will do an audit every year to make sure that you're spending the money wisely on the beneficiary. So no need for anything else. If you're a regional center client, just know that when you turn 18, you can ask for what are called independent living services. And part of that is help teaching the consumer to manage their money. Another way to manage finances is to establish a special needs trust, or what is called a pooled special needs trust. And that's through an estate planning attorney / elder law attorney. And the person who handles the money is called the trustee, and there are things that you can spend the money on, and so the trustee has to make sure to spend the money on things that are allowed under the special needs trust. A lot of times people establish special needs trusts to be able to qualify for public benefits, Medi-Cal, SSI, because if done properly, the assets and the income that is placed into the special needs trust is not counted for purposes of eligibility for some of these programs. Another thing that you can do is open up a joint bank account. So let's say my mom and I open up a joint bank account. All my money goes into this joint bank account. Of course, at being joint owner of the bank account, my mom can write out checks, can make deposits, can do the banking. A caveat, especially if you're on Medi-Cal or SSI, maybe other public benefits like CalFresh, I don't know about that, but it's best not to commingle your money. So my mom shouldn't be putting any of her money in that joint bank account. It should be only my money, because if my mom starts putting her money in there, that may cause problems down the line with other benefits. So don't commingle the money. Another way to manage finances is to open up an ABLE account. In California, it's called CalAble, and we're going to put a link to the CalAble program in chat. And with an ABLE account, you can put up to $16,000 in the account, and that money that's in an ABLE account does not affect your eligibility for Medi-Cal, for some federally funded programs, for SSI. And anyone on SSI can have up to $100,000 in this account, and it will not affect their eligibility. Versus if you don't have this account and you're an adult, you can't have more than $2,000 in countable resources, because the moment you go above $2,000, your SSI is suspended. 12 months of continuous suspension equals a termination. And if you're terminated, then you have to reapply for SSI. So if I am eligible for opening up an ABLE account, when I'm opening up the ABLE account, I can assign an authorized legal representative. So I can assign my mom to be my authorized legal representative, and she will have access to the account. She handles the account, puts money in, takes money out to pay for qualified disability expenses. I do a whole training on the ABLE program, the CalAble program. There's lots of information to share. So next slide. Just know that I want you to know that under Welfare and Institutions Code, Section 4655, this is the statute, also known as the code. So the Lanterman Act is state law. It's not federal law. When you leave California and you go to another state, don't expect to see the kind of system we have here, the regional center system. This is probably the only state that I'm aware of that has this kind of system. Other states may have other programs for people with disabilities, but nothing like what we have in California. So what the Welfare and Institutions Code is a state code / statute, synonymous, the law, and it's called the Lanterman Act. But the Lanterman Act is made up of a bunch of welfare and institutions codes, one of them being Section 4655, and that authorizes the director of the regional center to authorize some medical, surgical, and dental treatment in certain situations where the consumer of the regional center doesn't have anyone to authorize to give consent to these procedures, or does have someone with that authority, but that person is not responding within a reasonable time. If that's the case, then the director can give consent or not. Also, the director can initiate the process of conservatorship if necessary. And so the code section is found in that link. So I'm going to stop right now because we finished the PowerPoint, but I still have things to share with you, which is that California court website and that law that hopefully will be passed. I want to tell you about it and what it could do. So we're going to go ahead and stop the recording and see if
for a second. Perfect. I just want to be sure that we're resuming the recording. Thank you.
Okay. So
Thanks.
this website under conservatorships, which is what you're looking at right now, talks about it. There's a whole, there's information on understanding conservatorships, the handbook for conservators, so you understand what your rights and obligations are as a conservator. And then as we start scrolling down, there's types of conservatorships, types of probate conservators, duties of the conservator, who can file a conservatorship, alternatives to conservatorship, which has been the training today, the conservatorship court process, the role of the investigator, the role of the regional center, ending conservatorships. There are sometimes temporary conservatorships, the role of the regional centers. There's a whole section on limited conservatorships. And there's a different kind of conservatorship for people with mental health disabilities. So lots of information there for you. Also on the left-hand side, if you click the California Self-Help and Family Law Facilitator locations, it'll pop up a lot of different sites of self-help, I guess, clinics or centers that you can contact. So lots of good information on this. Also, visit your own San Mateo Superior Court website, because you probably will find a lot of information there too, on conservatorships and limited conservatorships. We're not going to talk about Assembly Bill 1663. And let me know when that is up.
It's up, Maria.
Okay, so this is a bill that is backed by many organizations, including the State Council on Development of Disabilities, our organization, DREDUS, the ACLU, California Committee Living Network, Disability Voices United. And so what does this do? Well, why did this bill come about? Because of what happened with Britney Spears. It exposed a lot of flaws in the California probate conservatorship system. showing how easy it is for someone to be trapped in a conservatorship and how hard it is to get out of that. And that movie, if anyone ever saw it, will just underline what I've just said. And so what was the solution? The solution is to ensure that people with disabilities retain their rights as a default. So courts would be required to ensure that alternatives to conservatorship are tried first while improving protections for those already conserved. The alternatives to conservatorship will, in this bill, include supported decision-making or civil support, right? And it will be in the law as a formal alternative to conservatorship. So first thing this bill wants to do is deflect, avoid conservatorships by recognizing alternatives. So not only will it establish supported decision-making as the less restrictive alternative, it also creates a technical assistance program to provide training, grants, and technical assistance to promote and strengthen the use of supported decision-making and supports. It's going to make probate conservatorship a last resort. Remember, conservatorships are in the probate department. That's why they call them probate conservatorships. And it's in the probate code, all this stuff about conservatorships and limited conservatorships. It's going to require alternatives be tried and considered by the courts before establishing a conservatorship and assess a person's ability and capacity with supports, not in isolation. It's going to create a conservatorship diversion program in all courts to identify conservatorship petitions where less restrictive options may be appropriate, and to discuss and educate the parties on those alternatives. It's going to make conservatorships easier to end. It's going to give the conservatees, the person who's been conserved, information that describes their rights and who to contact if they want to end the conservatorship. It's going to require courts to appoint attorneys and set a termination hearing if the conservatee wants to terminate their conservatorship, and allow courts to terminate conservatorship without a hearing if both the conservator and the conservatee agree to termination. And lastly, it's going to ensure that conservatees have a choice in their lives. It's going to require conservators to consult and make decisions aligned with the conservatee's wishes. Apply an order of preference to all conservators, including for regional centers, to ensure the court first considers family members or trusted individuals as conservators before appointing unrelated parties, because there are companies that act as conservators, like in that movie I was talking about. And require conservators to support the capacity and abilities of conservatees and encourage and facilitate the use of supported decision-making within conservatorships to the greatest extent possible. There's a way to follow this bill, and Mary or Lonnie can put the link, and you would sign up to follow the bill. So every time it moves along or it's amended, you'll get notified of what's going on. Also, you can probably get a lot of information at Disability Voices United if you're interested in what's happening with this bill. So we've come to the end of the training. I'm going to stop right now.